In recent years, it's become increasingly common to hear the claim that the government is producing secret law. Now, this is a serious allegation because in our republic, we presume that the law is public. It's available for the people to be able to look at and to see, and it's made in public by our Congress and by federal agencies and by the courts. I've examined this claim, looking at the available evidence in all three branches of the federal government, and it's my conclusion that there is a limited amount of secret law, but that it does exist, and we need to come to terms with secret law. So I define secret law as legal authorities, legal documents that require compliance, but that are not shared with the public. There are a lot of legal documents out there, advice offered by lawyers to their clients, that are legal documents, but they don't actually require compliance. And that type of internal advice, attorney-client privilege protects it, and there are a lot of good reasons not to have that shared with the public. But where you have a binding rule which reflects the law of the United States, there's a natural public interest in having access to that because the people under our Constitution are sovereign. I used to work for the U.S. Senate doing national security work, and something that we are all aware of is that there are secure rooms at the Capitol where members of Congress and appropriately cleared staff can go and review classified documents. And so what I would say is that any legal document which is binding and law produced by the judicial branch or by the executive branch should be shared with Congress in classified form, and then the representatives and the senators can go and have a look and be aware of all the law of the country, both public and secret, when they write public law. And the first one is the supremacy of public law. And by that I mean that the law that we see in acts of Congress, in regulations from federal agencies, and in judicial opinions, the law that we can all read, and the law that we can ask our representatives in Congress to change or to cancel or amend, that public law actually is the law, and that it's supreme over whatever amount of secret law might exist. And insofar as there is secret law, which provides more detailed guidance to intelligence agencies and to the military in secret, that more detailed secret law stays within the four corners of the public's understanding of what the law allows. And we don't see in secret the powers of the federal government expanded. So that's one principle, the public law supremacy rule. A second principle is we shouldn't have any secret criminal laws. And I call this the anti-Kafka rule, referencing Franz Kafka and his famous book, The Trial, which was a work of fiction, but he posited somebody who was tried and executed on the basis of a secret criminal law that he never saw and evidence that was never presented to him. Now, it's my conclusion, having served in all three branches of government, that we don't have any secret laws, and we don't have any secret criminal laws. And we can be reassured by that, but I think it's still valuable to articulate a broad principle that we don't have secret law that has substantive criminal offenses within it, because some countries have gone in this direction. A third rule of the road is that the public is notified whenever a new secret law is created. I call this a bell ringer. And by that, I simply mean a public announcement, such as on a website, in the Federal Register, that simply says, on this date, a new secret law was created by this agency. It concerns this subject, and the subject could be one word, like surveillance. This is its effective date, this is its termination date, and declassification date. And with that, then, the people would be able to know how often the government is creating secret law. They could ask their elected representatives in Congress to go into a secure room at the Capitol and view this law. And then those representatives could come out and say, obviously without divulging any classified factual details, they could say, we're comfortable with this, that this stays within the four corners of public law. Or they could say, we're concerned about this. And then there'd be an opportunity for Congress, either through public law or in one of the classified annexes to a public law, then to change it. And the final kind of rule for the road that I would propose, and it flows from the last one, is that all secret law produced by any branch of the government is shared with Congress. And that's very important. So Congress, when it writes the law, is aware of all of the law. And so if there's some sort of secret legal interpretation of a law that would seem to conflict with public law, then Congress can emphasize that a federal agency has gone too far and kind of pull them back.